So, good morning, everyone, and welcome back to our weekly webinar series. Um, we are today taking up a very important topic, and I'm sure that uh, most of us are very much interested in understanding that what kind of waivers, what kind of concessions, what kind of reliefs can be sought in a resolution plan. And this is a very large subject, and uh, I will ask Anil sir to take it forward.
Thank you, Ankit. This is our 73rd weekly episode, and we call it as AAA Weekly Webinar Series. This time, like yesterday, I had to go to Mumbai on an urgent basis. So the content that I was making in the flight got erased because the charger was left at home, the laptop charger. So the contents are made, but the PPT has not been made because then overnight the contents were made. But then we couldn't find time to make the PPT. See, the subject of the waivers and concessions and relaxation under a resolution plan is actually very controversial, and I think it requires some clarity. So it's a conceptual clarity which is more important rather than item-wise what is possible, what is not possible. Of course, we will come to that also. But in today's webinar, we are focusing ourselves on the basic concept of the waivers, relaxations, and reliefs under the IBC, under the resolution plan, and we will not touch much about the liquidation process. Then that actually can be a separate webinar, but then we will touch a little bit about the waivers and concessions under the liquidation process. But that's not very complicated. The most complicated is the waivers, concessions, and reliefs during resolution process and resolution plan approval. So we have the contents which are made on a Word file. I will be sharing that with you so that everyone can read the sections and the law regarding the waivers and concessions. So let me share my screen. See, what I'm trying to say that in today's episode, we would be discussing the basic concept. And then in the second part of this subject, we would come up to you with various judgments where some of the waivers, some of the concessions have been allowed and some of the concessions have not been allowed. So therefore, the subject being very large, it actually is divided into two parts. So just sharing my screen with you. I hope, Ankit, it is visible.
Very much.
So we are going ahead with this subject like waiver concessions. So before we start, we need to understand what is the law related to the waivers and reliefs and concessions under the Insolvency and Bankruptcy Code and the regulations made thereunder. First of all, I may say that there is no word used in the code or in the regulations like waivers, concessions, or reliefs permitted or not permitted under the law. So the subject has not been dealt with in this manner, that there are some kind of waivers or there are some kind of concessions when we get a resolution plan approved. So I am actually emphasizing that there is no word used in the code regarding waiver, no word used as concession, no word used as reliefs in the code as well as in the regulations. So the reliefs are basically provided under the structure of the Insolvency and Bankruptcy Code. The entire structure of a resolution process is made in such a manner that some things will get automatically waived, some reliefs will automatically come to you when a resolution plan is approved. Now, when we talk about liquidation process, most of the reliefs are basically provided in the waterfall mechanism under section 53 of the code. Now, Section 53 of the code only deals with the companies under the liquidation process and not the companies under the resolution process. However, under Section 30, subsection 4, the committee of creditors can consider the priority of charge and the value of security interest of the creditors as provided in Section 53. That is the only thing which is mentioned in Section 30, subsection 4, which is the section dealing with the resolution plans and not with the liquidations. Now, the other regulation which is important is Regulation 37 of the CIRP regulations, which provides for all the measures which can be taken up in the resolution plan for the purpose of resolving the stress of the company. Therefore, the reliefs, concessions, and various kind of waivers, these are not the subject which is specifically dealt by the code or the regulations, but it is out of the general understanding of the entire concept and also through various case laws. Going forward, let us first of all understand the concept of the resolution process. I will not go into the detailing. I will simply say that the concept, overall structure of the resolution process is then IRP or RP is appointed by the adjudicating authority on an application under Section 7, 9, or 10. And moratorium under Section 14 is set in to facilitate RP to conduct the process without much hurdles. Then the management is also taken over by the RP immediately, and the powers of the directors are suspended under Section 17 of the code. RP takes the control and custody of all the assets, all businesses, operations, bank accounts, etc. under Section 18 of the code. Then all the employees and the persons associated with the management, they would start reporting to the IRP or RP, and they will also cooperate with the IRP or the RP under Section 19, and RP will keep the company as a going concern. And all the above actions are basically why? All the above actions are basically to protect the assets of the company, to continue the operations so that the value of the business is not minimized, to continue the service to the customers, to the market. So that is the effort in this process, that the company should be taken away from the management, that management who is responsible for the default, and the company may be handled by the RP, and the RP will keep the company as a going concern, will protect the assets of the company, will also protect the business of the company, will also continue the operations, and will also keep the company as a going concern. That is the basic structure on the asset side. So there are basically two things which are very, very important under the IBC structure. One is the asset side of the company, understanding the asset side of the company. I'm going forward, I will also come to the scenario where the understanding and the valuation of the asset is also a very, very important part of the process. Whenever I say process, that means the resolution process. Now, it is the duty of the RP to understand the assets of the company, business of the company, including tangible, intangible, fixed, current, intellectual property rights, goodwill, contingent asset, litigation asset. All the assets are supposed to be, first of all, understanding has to be developed by the RP, and then later on the valuation also has to be done. And third, the RP will also take all the custody and control so that the RP is able to hand over to the new buyer or the new management. So the old management is handing over everything to the RP, and the new management will come and the RP will hand over to the new management. This is the overall structure regarding the assets of the company is concerned. And also all these assets, whatever I said, the RP is supposed to get this valuation done. Now, based on all this understanding of the assets, understanding of the litigation assets, understanding of the RP is also supposed to prepare an information memorandum under Section 29, and that information memorandum will be shared with the prospective resolution applicants. Now, the resolution plan is prepared based on the information memorandum. If that information is not provided in the information memorandum, that actually means that we need to understand how this information has come to the resolution applicant, and the RP should also immediately rectify that IM in case that information is correct. Now, some of the definitions that are very important for the assets part. The definition under section 3 subsection 27 defines property, because whenever a word property is used in this entire code, it includes money, goods, actionable claims, land, and every description. Whatever assets of every description or even actionable claims, all this is called a property, and actionable description of property situated in India or outside India, and every description of interest, including present and future, or vested or contingent interest arising out of or incidental to the property. Now, what that means, anything which is in the name of the company, in India, outside India, any kind of rights, any actionable claims that may be even vested today, owned today, or it may be contingent on something, or any kind of interest, that is all called property of the company. And the RP is supposed to get all this valued. RP is supposed to get all this valued so that the prospective resolution applicant must understand what is the real value of the company. So therefore, the information memorandum has become very, very important document for the purpose of overall resolution. In the information memorandum, the total description of the business, in the very recent amendment, even the IBBI have also amended the regulations where the brought forward losses, as that also can be considered as the one of the asset of the company, and that information must be provided in the information memorandum. And any other intangible, any other beneficial thing that can also be provided in the information memorandum. So basically for the purpose of understanding the assets of the company, the businesses of the company, the RP has also given powers under Regulation 4 of the CIRP, where the RP can actually seek information from the depositories for any kind of investments held in the name of the company, any kind of professionals which are appointed by the company and the RP can reach out to those professionals and seek information. Then the information utility is also supposed to provide information to the RP. Other registries that record the ownership of the asset, that the registrar of documents, registrar of trademark, registrar of vehicles, registrar of vessels, registrar of aircrafts, all these are the registrars where the ownership of the assets are recorded. So these registrars are also supposed to provide information to the RP. And then all the shareholders, members, promoters, partners, board of directors, joint venture partners, all are supposed to provide information to the RP. The RP has the power to seek information from all of them, and also the contractual counterparties of the corporate debtor. Contractual counterparties can be those who actually are supplying some key material, who are actually having some kind of joint venture with the company, who are actually having some kind of other arrangement, which is the contractual arrangement with the company, maybe that on the asset side, maybe on the obligation side. So that information the RP can seek from all those persons. Now the Regulation 4, Sub-Regulation 3 further states now that this is something which is recently added in the regulations, that even the creditors will provide all the information about the assets and the businesses of the company by way of sharing with the RP the valuation reports that the creditors have got it done, like the banks and financial institutions, and the stock statement, receivable statement, inspection reports of the properties, audit report, stock audit report, title search report, technical officers report, bank account statements, and other such information which shall assist the interim or a resolution professional in preparing the information memorandum. So these are something which is an important, very, very important part. So then let us understand the first part, that the RP has now understood the assets of the company, all contingent assets, all tangible, intangible assets, goodwill, operations, and RP is keeping the company as a going concern. So that's what is very, very important, that the RP has taken over the business. And now coming to the liability side. Now, when we come to the liability side is very, very important, because see, the liability side is primarily being managed through the process of submission of claims to IRP or the RP. When we say the liabilities are only those liabilities which are submitted as claim, and some of the liabilities, of course, like as far as the workers' liabilities are concerned, that has to be taken, that can be taken by the RP from the books of account in case the books of accounts are available with the RP. Now, let us understand, first of all, the claims are invited by the RP and submitted by the claimant along with the security interest. That is the first process in the entire resolution process. Now, when we see the section 3, subsection 6, the definition of claims is very, very important. Now, the entire structure of the IBC is based on the definition of claim, the overall concept of claim, and finally the judgment of Ghanshyam Mishra and Sons Private Limited, the Honorable Supreme Court judgment. So the entire concept of waivers, waivers of liabilities, waivers of obligations, waivers of taxes, everything actually comes out of the concept of claim, and finally the Ghanshyam Mishra and Sons Private Limited judgment of Honorable Supreme Court. Now let us understand what are the claims. The claim means a right to payment. That means that in case there is any right to sue a person, sue a company for any kind of criminal or a prosecution, that is not a right to payment. Right to payment is that any kind of right which can actually get converted into payment obligation. That can be a penalty, that can be a damages, that can be an interest, but that cannot be a prosecution, that cannot be an imprisonment. So all those claims, wherever, all those disputes, all those rights which can be converted into payment, whether or not such right is reduced to judgment, whether the judgment has been passed or not, that's a claim. Because if a person says that you have broken a contract, and because of that contract that you have broke, there is an obligation on you as per the agreement, and you have to pay me something, and that of course is pending with some court for adjudication. So that's my claim, and I have to file that claim before even I cannot wait for that claim adjudication, but I have to file my claim. Whatever claim I have submitted to that court, that claim I have to file before the RP also, whether that particular judgment is passed or not, whether the application. But the only thing is there has to be some claim, some kind of right which gets converted into money, that is a claim. Fixed, whether that particular amount is fixed or not. Disputed, whether the amount is disputed or not. Undisputed, legal, equitable, secured, unsecured. So any kind of right to payment is the definition of claim. Now clause B. Now the clause B says a right to remedy for breach of contract under any law for the time being in force if such breach gives rise to a right of payment, whether or not such right is reduced to judgment, fixed, matured, unmatured, disputed, undisputed, secured or unsecured. So this is the very, very important part of the definition of claims, a right to remedy for breach of contract. So first of all, we stay on this right to remedy for breach of contract under any law. That can be the Transfer of Properties Act, that can be Sales of Goods Act, that can be any other like Patent Act or any other Trademark Act. If there is a right to remedy for breach of contract under any law for the time being in force, if such breach gives rise to a right of payment. No, again, right to payment. So if that kind of breach gives a right to financial payment, whether or not such right is reduced to judgment, fixed, matured, unmatured, disputed, undisputed, secured or unsecured, that's all again repeating. But see, what I'm trying to say is that any contract to pay, any dues, and any breach of contract, any damages, any compensation, any kind of financial compensation from any breach, that also will be considered as a claim. Now, such a vast definition of claim actually will protect the successful resolution applicant after the resolution plan is approved. Because nobody can say that I did not submit my resolution. I did not submit my claim because that was pending before a court. Because whatever is pending before a court, if there is a claim, that you need to come and submit that claim. But in case the claim is not submitted, now let us see what is the process of submission of claim. The claims are submitted by the operational creditors. It is provided, it is also in operational creditor, includes government authorities, then financial creditors, class of creditors, workman and employee, and there is an other clauses, other creditors. Now there can be other creditors, there can be an employee of the company who still have dues. There can be an ex-partner of the company who still have some dues from the company. There can be so there can be, because in the case of LLP, there can be other creditors also. There can be a dispute between the management, and that management dispute actually will convert into some right to payment. There can be a suit of mismanagement and operations before the NCLT between the management, and the NCLT may pass an order where some right of payment is getting generated. So those are all other creditors, because there is no loan, there is no debt, there is no supply of goods or services, there is no relationship of workman and employees, and they are not government authorities. So those are the other creditors. So those other creditors will also file their claim. Now then the RP will see the evidences and the substantiations of the claim, and RP will admit the claim. RP is not supposed to adjudicate. RP is only supposed to collate and verify, because the wording written in the code is collation, whereas the wording used in the regulation is the verification. Therefore, now in this process, you see the RP has got the claims and some of the other definitions which are very, very important, that all the liabilities will come to the knowledge of the RP, and these liabilities will also be mentioned in the information memorandum. Now, the section 3 subsection 10 is also defining the creditors. Means any person to whom a debt is owed and includes a financial creditor, an operational creditor, a secured or unsecured creditor, and a decree holder. That's the definition of creditor. Now, to whom a debt is owed. This is very important. To whom a debt is owed. So the word creditor comes from a debt. And then the second part of the definition is only classification of the creditor, which means financial, operational, secured, unsecured, and a decree holder. But then the main basic creditor comes out of a debt. And now let us understand what is a debt. Now the debt, when we see the definition of debt under section 3 subsection 11, the debt means a liability or obligation in respect of a claim. Which is due from any person and includes a financial debt and operational debt. Now, coming to one thing, and then when I see the operational debt, the definition of operational debt is provided in section 5 subsection 21. Now this operational debt is getting definition. The definition of the operational debt means a claim. Again, it starts with a claim in respect of the provision of goods or services, including employment, or a debt in respect of the payment of dues arising under any law for the time being in force and payable to the central government, state government, or any local authority. So this is the definition of operational debt. Now, let us understand what exactly I'm trying to focus. One thing, it's very, very important that what I'm trying to focus is that everything is claim. The debt means claim. The operational debt means claim. The financial debt means claim. Creditor means debt. Debt is what? A claim. So everything finally comes to this definition of claim. Disputed, undisputed, equitable, illegal, undisputed, fixed. Everything comes to this particular judgment, that everything comes to the claim. So if a claim is filed and then the claim is handled by the resolution plan, nothing else is left. Then there is nothing left. There is no dispute is left. There is nothing like whether fixed or not, whether equitable or not, whether disputed or not. So no dispute is pending. Once a claim is filed and the claim is settled through a resolution plan, then nothing is pending. That means once a claim is filed and it is settled through a resolution plan, that means nothing is pending. Nothing is pending. Now I'm actually coming to another very, very important part of it. First, I said that the claim, and then I said the entire debt, operational debt, financial debt, all are basically the claim. I will actually say, because see, the secured or unsecured, that also is actually very, very important. Like security interest, the definition of security interest under section 3, subsection 31 means right, title or interest, means right, title or interest or a claim to property, or a claim to property created in favor of or provided for a secured creditor by a transaction which secures payment or performance of an obligation and includes mortgage, charge, hypothecation, assignment, and encumbrance of or any other agreement or arrangement securing payment or performance of an obligation of any person. No, one is the securing payment. The second is securing performance of an obligation. So there are two things. One is securing payment and the other is securing performance of an obligation. Because what I say that in case I have entered into an agreement to sell on a property, and that company has gone into insolvency, I become a secured creditor because I have a right. I have a right of specific performance of an obligation. As a person who enters into a contract with a company to buy any property of that company, then I become secured creditor. I become secured creditor because I have a right of performance of an obligation. So therefore, I become a secured creditor. So this is what I've been saying again and again, because this definition of security interest is different definition as compared to the definition given in the SURFACE. It is a different definition as compared to the definition given in the Companies Act. So therefore, the definition of security interest covers wherever right of specific performance is also given to any other person. Right of payment is also given. Right of payment is very simple. When we actually take a loan or we create a liability, and then we create a mortgage, charge, hypothecation, assignment, or encumbrance, that is a right to payment. But right of specific performance, like the home buyers, when a home buyer enters into a particular agreement to sell, that home buyer has a right of specific performance against that company, against the builder. To my understanding, that right of specific performance also comes under the security interest, and that right is available with the people who have actually entered into any kind of agreement which is enforceable under any law, maybe Transfer of Properties Act or Sales of Goods Act or any other like Motor Vehicles Act or any kind of Vessels Act or Aircraft Act. So there are certain cases where the agreement has been entered, right of specific performance has been created in my favor, and that company goes into insolvency, then I should become a security, I should have a security interest on that particular asset. So provided that security interest shall not include a performance guarantee, that's a totally different issue, because the performance guarantee is slightly different. Performance guarantee is not a security interest. Performance guarantee is considered to be a warranty. Performance guarantee is not a security interest. Now, let us understand the concept of submission of claim, the definition of claim. And now when we see the section 15, subsection 1, clause C, the public announcement has to be made by the RP as per the, and the last date for submission has to be provided. When we see regulation 6, sub-regulation 2 and clause C of the CIRP regulation, the public announcement shall provide the last date for submission of claim, which shall be 14 days from the date of appointment of the IRP. Then we go ahead and we see the regulation 12, sub-regulation 2 of CIRP regulation, which says that a creditor who fails to submit, claim with proof within the time stipulated in the public announcement, which is 14 days, may submit the claim with proof to interim resolution professional or the RP, as the case may be, on or before the 90th day of the day. No, I'm only trying to say, like, the law is now actually getting very clear that the 90th day is the maximum time that the claims can be submitted. Of course, the government, the Ministry of Corporate Affairs on 18th January 2023 has issued a kind of notice. It is issued a kind of communication that these are the proposed changes in the IBC, and they sought comments. So in that particular proposed amendment, it is also one of the amendment that the claims may be admitted before a resolution plan is approved. So that concept is getting concluded that if a claim is not even submitted up to 90 days, then if it is not even submitted up to the date of approval of resolution plan, then there is no further possibility of submission of a claim. Then Regulation 12A of the CIRP says the creditor shall update claim as and when the claim is satisfied partly or fully, and that is also the duty of the IRP to update the claim in case there is any changes in between. Then again, the duties, section 18 subsection B says that the RP or IRP is supposed to receive and collate all claims submitted by the creditors pursuant to the public announcement. Then the regulation 13 of the CIRP claim says that the RP or the IRP, they shall verify every claim as on the insolvency commencement date within 7 days from the last date of the receipt of the claims, and thereupon maintain a list of creditors containing name of the creditors, amount admitted, amount claimed, and the security interest, if any, in this regard. Now, section 14 is also saying the determination of the claims. Now, this is very important. When I am saying the entire concept of the claim, I am saying that the entire structure of the resolution process is based on the claim. All the waivers, all the concessions are based on the claims. It is not based on section 53, because section 53 is applicable only in liquidation. Now, in this case, like say the determination of the amount of claim, this is another power with the RP under regulation 14, that where the amount claimed by the creditor is not precise due to any contingency or any other reason, the IRP or the RP, as the case may be, shall make the best estimate of the amount of the claim based on the information available with him. And this sub-regulation 2 says that the RP or the IRP shall revise the amount of claims admitted, including the estimates of the claim made under sub-regulation 1, as soon as may be practicable when he comes across additional information warranting such revisions. Now, there may be some kind of disputed claims, there may be some kind of contingent claims, there may be some kind of litigation, there may be some kind of unsettled amounts that the RP has to admit the claim based on the estimate. I have seen the RPs admitting the claim at ₹1 and also narrating that this is a dispute, and that dispute definitely, because the estimate is not available, I'm not sure what amount will be passed by what kind of claim will be passed by any authority. So therefore, those claims are admitted at ₹1. That's also important. Now, since we have seen the assets, we have seen the liabilities, and we have seen the process of submission of claims. Now, I'm saying that the information memorandum is prepared under section 29 and as per the regulations. Now, what exactly information memorandum is? Information memorandum is something, all the highlights of selling proposition. Like when as an RP, I'm selling this company now, I have to issue an information memorandum, and that information will also provide some highlights. What are the highlights of this company? What are the highlights? What I'm trying to sell, focused selling. Significant information about the corporate debtor, including its operations and the financial statements. Now, in this information memorandum, all my assets and liabilities are given with the descriptions. My annual financial statements are given. My audited financial statements are given. List of creditors are given. But the most important is that the particulars of debt due to or corporate debtor with respect to related parties, details of guarantees that have been given in relation to the debts of the corporate debtor by other persons, specifying which is the guarantor and is a related party. This also is important, because this also can be settled through the kind of a resolution process. The name and address of the members, like shareholders, partners, at least having the 1% stake. Then the details of all material litigation and ongoing investigations and proceedings initiated by the government and statutory authorities, the number of workers, employees, and the liabilities of the corporate debtor towards them. Now, this is not based on the claim. the number of workers and employees and the liabilities of the copywriter towards them. So this is what probably the most of the judgments have. We will see that the RP is supposed to even provide this information based on the books of account, even if the claims are not filed. Even if the claims are not filed by the Provident Fund Department, and if the some kind of see, the only issue is the only thing that I'm trying to say, recently in the last 1 week, the Supreme Court has actually given a judgment saying that the Provident Fund authorities are supposed to file their claim on time, and in case the claims are not filed on time, then that concerned officers should also be reprimanded. That's a Supreme Court judgment. So the ultimate focus in the entire profession is coming on the claims. In case the claims are filed, it will be settled. In the case the claims are not filed, it will be lapsed. So ultimately, whatever even the disputes are there, even the demands are there which are not yet settled, but it has to be submitted as a claim. Now, the recent amendment is that the company overview, snapshot of the business performance, all this is important. And when this information memorandum is made, then the resolution plan is submitted. And in the resolution plan, everything is settled. In the resolution plan, the whatever is payable to any creditor, that is provided in the resolution plan, that is based on the value of the assets, and that is based on the acceptability by the creditors. So there are 2-3 things that is very important to understand. If the liquidation value of the company is higher, that amount is also payable to operational creditor. If the liquidation value of the company is lower, the amount will be paid to the CIRP cost and the secured creditors, and then according to the waterfall arrangement, that's what is provided in section 30 subsection 4. Also, it depends upon the committee of creditors. There may be some cases where the unsecured financial creditors are more in numbers, especially for those cases where the home buyers are unsecured financial creditors, and since they are having more voting power, and also the Supreme Court has held multiple times that the completion of the project and the completion of the construction is the first objective of the insolvency of the real estate companies. So therefore, in that particular scenario, the section 30 subsection 4 is not being complied with, because the word written there is may, it is not shall. However, in the case of liquidation, the word is shall, that it has to be distributed in that fashion only. So therefore, in the case of real estate companies, the home buyers who actually have the unsecured financial creditors priority, but they actually can get much before, immediately after the CIRP cost. So this is what is the strength of a resolution process and not the liquidation process. In some other resolution processes where some other unsecured financial creditor, like the depositors or unsecured debenture holders, are more in number, and they actually can say that the resolution plan will have this much voting. So they can also take more share, which is not according to the waterfall mechanism, and which is based on the overall understanding of the company, overall assets of the company. Now, Ankit, at this moment, I would like to say that I am trying to explain the overall concept. Now, basically, when I'm saying this concept of claims, now I will immediately go, once a resolution plan is approved based on the claims. Now, let us try to understand what Ghanshyam Mishra and Sons Private Limited versus Edelweiss, the Honorable Supreme Court case, says. Now, that particular case actually says, because there are many things that we have with us, there are many other things that we need to discuss, but today it's a conceptual clarity that I want to bring. So the Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company say that once a resolution plan is duly approved by the adjudicating authority under subsection 1 of section 31, the claims as provided in the resolution plan shall stand frozen and will be binding on the corporate debtor and its employees, members, creditors, including central government, any state government, any local authority, guarantors, and other stakeholders. That's what is provided in section 31, subsection 1. Then the Honorable Supreme Court further says, also held that all dues including statutory dues owed to central government or state government, any local authority, if not part of the resolution plans, shall stand extinguished, and no proceedings in respect of such dues for the period prior to the date on which adjudicating authority grants its approval under section 31 could be continued. So claim can be submitted for each and every item, whatever is convertible into money. Whatever is not convertible into money, that means that might even turn up to the prosecution and imprisonment, that cannot be converted into money, so that cannot be the part of the resolution process. However, the company would stand protected because the company is a juris person, the company cannot be imprisoned. So whenever it comes to the imprisonment, it will go to the ex-management, suspended management, or the key managerial personnel. Whenever it comes to the financial liability, it will come on the company, but that is all based on the claims. In case the claim is not filed, that actually gets lapsed, that cannot be filed later on. After the resolution plan is approved, no claim can be filed. Therefore, the entire concept of waivers, reliefs, concession is based on the claims, based on the approval of the resolution plan where no claim has been filed. So in case anyone who actually could not file their claim, whether that liability is appearing in the books of account or not, that means that claim cannot be filed. That claim stands lapsed. The Supreme Court has held many times that no Hydra head cannot pop up every day. That's what is the statement given by the Honorable Supreme Court, that Hydra head cannot pop up every day, because there is a superstition that there is a creature in the sea where there is a head which pops up every day, and then if you cut that pop, another one will come up. If you cut that head, another one will come up. So that is a Supreme Court has taken that kind of connotation, and the Hydra head popping up, that is not accepted in the resolution process, and the no successful resolution applicant is under obligation to deal with all the claims coming up after the resolution plan is approved. He has to simply say that the claim process is all closed. You have failed to file your claim, so there is nothing that you can file now, because your claim pertains to the period prior to the approval of the resolution plan under section 31, which is very clearly said in this resolution plan. So the entire concept of resolution plan, the entire concept of waivers, reliefs, it comes from the concept of claim. So I see now, then before I actually go to regulation 37, in fact, is something which is important. But then before I go to regulation 37, I will have to go to section 30 of the code, which says that the resolution plan will be submitted along with the affidavit and all that, the resolution, that because the promoters are not participating. So the resolution plan must provide that the CIRP cost will be paid in what manner. Then it also must provide that how the liquidation value which is due to operational creditor, how the same will be paid. The liquidation value which is due to dissenting creditor, how the same will be paid. And then the subsection 4 says that the committee of creditors may approve a resolution plan by a vote of not less than 66% of the voting share of the financial creditors after considering its feasibility and viability, the manner of distribution proposed, which may. Now, the manner of distribution which may take into account the order of priority amongst the creditors as laid down in subsection 1 of section 53, including the priority and value of the security interest of the secured creditor and such other requirements as may be specified by the board. This section 30 subsection 4 is giving a reference to section 53. It is also giving a reference that the committee of creditors may consider the priority of charges. It also gives a reference that the committee of creditors may give a reference to the value of security interest of each secured creditor. But the distribution will have to be somehow along with the section 53, unless there is a compulsion or there is a voting disorder. Then after this resolution plan is approved by the committee of creditor, then the RP will submit this resolution plan to adjudicating authority, and the section 31 says that the adjudicating authority is satisfied. If the adjudicating authority is satisfied that the resolution plan as approved by the committee of creditors under subsection 4 of section 30 meets the requirement as referred to in subsection 2 and of section 30. Section 2 of subsection 30 means the payment of CIRP cost, payment of liquidation value to operational creditor, payment of liquidation value to the dissenting creditor, that part, which is section 30 subsection 2. It shall by order approve the resolution plan. Adjudicating authority shall approve the resolution plan, which shall be binding on the corporate debtor, its employees, members, shareholders, creditors, including the central government, state government, local authority, to whom a debt in respect of the payment of dues arising under any law for the time being in force, such as authorities to whom statutory dues are owed. It is also binding on the grantors and other stakeholders involved in the resolution plan. So other stakeholders involved in the resolution plan is very important. I would say that if a person is not a creditor and he has not submitted a resolution plan, he's not submitted a claim, that is a person who is not involved, because see, as far as the claims are concerned, he cannot submit a claim after the approval of the resolution plan. But like the approval of the resolution plan is not binding on my other contractual parties. Like suppose in a company, I have a contractual arrangement with my franchisees. I have a contractual arrangement with my customers. I have a contractual arrangement that I will give you this much of item, I will give you this much of item. So those contractual arrangements, which stands with the corporate debtor, those contractual arrangements are still valid even after the resolution plan is approved. If I am supposed to supply, as a corporate debtor, I am supposed to supply my product exclusively to a particular person. Now, that is something that actually I have to seek a specific approval from the adjudicating authority if I have to get out of that order, if I have to get out of that agreement. But the other party will have a right to challenge. How can his right be, because the other party is not a creditor, other party but then the other party will say that out of that agreement. Now let us understand that there is an agreement which says that this agreement cannot be terminated by the corporate debtor, and if it is terminated, this much of damages or this much of penalty will be levied on the corporate debtor. Now the corporate debtor is saying in the resolution plan that I am terminating this agreement. If there is any damages which are supposed to be claimed by the third party, they may claim. So that again will become a claim, and that claim will never come. That claim has not been submitted. That claim will be settled according to the resolution plan. So any contractual obligation of the company towards third parties, if there is a termination which is unlawful and that actually gets converted into some kind of payment, that also will convert into claim. But in case any termination will actually gives rise to a prosecution, that will not be waived. That will not be waived, because if as a distribution company, I have if I'm a telephone company, if I'm a mobile company, then I have so there are obligations of a particular business, and those obligations, if I terminate, and whatever claims comes out of those termination, that also will become claims. So any party who, as the resolution plan is binding only on those, who were involved in the resolution plan. Who were not involved in the resolution plan, they can still challenge that this particular corporate debtor, they were supposed to give entire supply to us. After this resolution process, they can't stop. They can't stop this supply to us. But then in case that particular termination is done, if that termination is done after the resolution plan is approved by the successful resolution applicant, I think the successful resolution applicant will have to deal with the damages. That he will have to deal with the damages. That is a separate issue. But yes, in some cases, I understand that the adjudicating authorities have given this kind of waiver. I will come to these kind of waivers later on. So, Ankit, I wanted to explain the concept today, and based on the Ghanshyam Mishra, the entire waivers. But then this is very important part of the entire resolution process is the Regulation 37. Regulation 37 has got many parts, and then after the Regulation 37 we have many case laws which actually can be discussed, where I can actually fortify my concept that all waivers etc are based on the concept of claims, lapsing of the claim, settlement of the claim. That is what is the entire concept. I think we can take up some of the questions today, and the Regulation 37 and various judgments that can be taken up in the part 2. And also you please understand like what I'm trying to say, you feel that it is a conceptual clarity would have gone to the our audience.
Yes, I think the message is clear that one, the increasing jurisprudence is about the idea that if there is no claim, then there is no right. So that's understood, and also you have very well, made everyone visit or revisit the definitions of the various liabilities, where again the word claim is used. So without a claim, the liabilities kind of don't really accrue. So that's important to understand. And I think after once we say that yes, there is a claim, then we can talk about the waivers and all the other things, because then those claims are treated in a specific manner. So that's understood, and I believe that we can also look into the complete judgment and the rest of the discussion in the part 2. With respect to the questions that have come in, interesting question that it's maybe not related to this topic, but anyways, this is the question is that the bank has extended a warehousing receipt facility to a CD, and the pledged goods were already sold by the bank, but the full liability has not been paid. So the bank had a security, and the bank has exercised that security and recovered everything from that security. So now, when the bank makes a claim to the CD, is it a secured or an unsecured claim?
No, this is an unsecured claim because see, there is no security in the
Which
name of the
exists
company
or which
where the
remains or
bank
which
has a charge.
remains which remains
Yeah, there is no
so
security
secure,
which remains.
yeah, so
No, but
that
then there is a separate issue. Like now, there is a separate issue, and that issue is that if the bank has not sold that particular property, that particular
stock.
stock, and but factually there is no stock. Factually, there is no stock.
Hmm.
Bank will still be called as a secured creditor because see, even if there is 1 paisa, 2 paisa, whatever, but that is like that confusion will always prevail. But when the valuation will be done, in that valuation, the value of security of the bank will be negligible or will be zero, but the bank will still be considered as the secured creditor. But in case the bank have sold the entire security, and for the balance amount, the bank cannot consider itself as the secured creditor.
So this is the old issue where we kind of talk about how the idea should be that the claim can actually be partly secured and partly unsecured depending on the value of security. So that's something that might be the right idea here in the
No,
long
no,
term.
I'm only trying to say that in case I have financed a car to a person and that person in fact sells that car to someone fraudulently, I would still
Hmm.
be considered as a secured creditor
Hmm. Hmm.
because that security has been fraudulently taken away. I mean, that is a separate issue. While I will be distributing proceeds under liquidation or under resolution, I will consider the value of the security interest of each creditor. That's a separate issue. But for the purpose
Hmm.
of classification, I would be classified as a secured creditor. In case I am a banker where I have given a secured loan and maybe that the security has already kind of vanished.
So then there's a question from Kunal Gaurav maybe, asking that covenant undertaking to create mortgage, would that be a security interest?
No, the
An undertaking to create mortgage or
security
a
has to be
covenant?
created.
Yeah.
Security has to be created. And undertaking to create a security is not a security. I have
Hmm.
promised to create a security. That is not a security interest. The definition of security interest is there has to be a transaction. I mean, if I just go back and like it is very important that since somebody has asked this question, let me go back to section 331, which is the definition of security interest. I will just, because this is an important, very important question in fact somebody has asked. So like when I say this section 3, like security interest is section 31, 331. And when I say created in favor of provided to by a transaction, if we see the by a transaction, that's very important that it is by a transaction which secures payment or performance of obligation. Now, when I say by a transaction, in the very next section 331, 33, the definition of transaction is also given. Includes an agreement or arrangement in writing for the transfer of the assets or funds, goods or services from or to the corporate debtor. That's a transaction. Now, when we actually say this word transfer, because this is a transfer word, then the transfer is also defined. Include sale, purchase, exchange, mortgage, pledge, gift, loan, or any other form of transfer of right. So that means transfer of property is also defined. So all this transaction, transfer of property and security interest, it has to be taken collectively. Just a promise cannot be considered as a security interest. The security interest is by way of a transaction. Transaction is by way of a transfer. Transfer is like transfer of property is separate and transfer of other things are separate. So this is not a promise. This is an actual transaction where the security interest will be created. Yes, Ankit.
So, apart from this, there's of course, we understand that if there is a claim that has been filed in the CRP period, the same can be considered by the liquidator without asking for the claim again as per the new regulations, right? That's very much understood.
I think if there is no interest component beyond this, otherwise the
Updated claim can be sought.
judgment of NCLAT is
Mhm.
that the all the creditors have a right to claim interest during CIRP period. In case
That's
that is
so
it.
if, but I think the story is that if the claim does not come in, then what do you do? So CRP period claim can be considered by the liquidator and that he can admit that claim, right? During
Yes,
liquidation. That's
we
was,
can consider. We can
yes,
consider. Yeah.
yes, yes. Um, so the so this is an opinion here which says that which is from Sukhdev Madnani. He says that the statement seems contradictory. In Ghanshyam Das case, the claim of creditor is extinguished if no claim is filed till the approval of resolution plan. Then again, it is said that the resolution plan is not binding on creditors who were not part of the resolution plan. Example, government dues are claimed later by government departments, GST, income tax, etc. So that's something that is.
No, I think it's very clear. The concept of claims is that you can file a claim up to a particular period. And if you are not able to file a claim, then you are not, you have no right to file that claim. And the resolution plan is binding on all those parties who are part of the process, who are part of the resolution process. See, like we are trying to say that there are some parties, they are on the, but you see, there are some liabilities and there are some assets. No, those companies which are actually those companies where those parties may not be part of the resolution process because see, they are not a claimant, they are not a claimant, and they have some other kind of relationship with the company. So you can't tell. See what I'm trying to say. In a resolution plan, if it is written that the Indian Oil Corporation will supply the oil for the next 2 years to this company. See, that's not acceptable. That's not binding on them because they are not part of the resolution process. In case it is said that the stamp duty would not be levied on the transactions for the next 2 years. Why? Because those parties, it is not binding on them. It is not binding on the stamp duty officer. They are not binding on all these kind of statement which is there in the resolution plan. So see, like if you see, like I have prepared various various kind of reliefs asked by the various kinds of reliefs which are asked by the various SRAs, various kinds of reliefs. and I have analyzed each and every relief which are for the past, reliefs which are for the future, and I would be deliberating all this in the second part of it. I think I would be making it very clear that what is the concept of who are not stakeholders, who are not involved in the resolution process. Like I cannot say that in future some person will keep on supplying to me. I will not say that some person will, after even termination of the lease, some person will renew my lease. They are not part of my resolution process. Why should the third party be binding on this particular resolution plan? Resolution plan may have anything which is not even which is not covered under the IBC structure. So those people are not binding on the resolution plan, even if it is approved by the adjudicating authority by mistake. Clear, Ankit?
Right. So that was another question from Mr. Rajagopal S, saying that if there was some kind of a lease agreement or a license and lease agreement which was entered with the third party, wouldn't the resolution plan override that lease agreement? So I don't think that can happen, right? The those agreements will stay in place between the creditors and third parties,
If
and you
if the
can't.
corporate debtor has given a property for 9 years lease, now the corporate debtor has gone into an insolvency. Now that means the corporate debtor cannot, the resolution applicant cannot say that that particular lease will be terminated. I mean, that is not binding on the tenant because the tenant is not part of this resolution process.
Right. So great. I think we will continue this next time and as part 2 and take it forward then.
So there are a lot of other things that we have collated together. We have worked hard on this. I have seen various resolution plans where various kinds of prayers are made, various kind of waivers and various kind of reliefs are also asked. I have even seen those kind of reliefs that the GST would not be applicable to this company for the next 2 years. I have seen those kind of reliefs prayers where it is said that the GST would not be applicable on the implementation part of this transaction a resolution plan. So all that is not available. It is not allowed because the entire process of waivers is based on the claims. Because if there is no claim, no waiver. If those parties are not part of the resolution process, no waiver. It is not binding on them. So therefore, as far as this, like I will also come to this that most of the benches are passing an order that as far as the income tax relief is concerned, that they will not allow. So I am saying when the liquidation value is known to the adjudicating authority, when the total claims are known to the authority, when they also understand in the resolution plans as per section 53, there is no possibility of any kind of distribution to the operational creditor, to the government authorities. See, they can easily say that based on the liquidation value, based on the fact that no amount is due to the operational creditors, therefore all the past dues of the government authorities stands waived. It is very easy for them to say, but somehow I'm not sure why they are saying that you go to the respective authorities and seek that waiver. That is something which is creating a lot of concern to most of the resolution applicants, because see, they are actually going from pillar to post to get all these kind of waivers, because the resolution plan doesn't say that it is allowed. Resolution plan says that we can't allow, although nobody other than the adjudicating authority understands the concept of the insolvency and bankruptcy code. Nobody understands the concept of the claims. Nobody understands that the liquidation value and the amount due to the operational creditors. If everything is understandable to adjudicating authority, then I think the adjudicating authority very easily can say that these stands waived. If they would start saying this, there will be more and more appetite for resolution plans and for taking over the companies. So I think with this, Ankit, we can close this webinar today. This subject is very, very interesting. I would request everyone to also come and join the second part of it. Thank you. Thank you very much.
Great. Thank you, everyone. Thank you so much.